Hello, good afternoon. This is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. I'm also here to talk about a particular topic. So today I'm going to talk about that situation where you get the 2-year green card. And then you're either separated or filing for divorce right after you get it. Your green card comes in the mail, or you end up going to the interview, and then you get the card a week later. But during that course of that time, you've been separated from your spouse. You know that, okay, this is not good. You're not going to go forward with your spouse anymore, or you're divorcing. This is a very realistic possibility that happens, but then it raises complex questions. I know that when individuals get their 2-year green card, they know, okay, it's going to be up in 2 years. I'm separated. I'm going to need my spouse to get the 10-year, to go from the 2-year to the 10-year. So what next? So I'm going to tell you what's next is you're going to have to evaluate. Now, it doesn't stop you from applying for your 10-year. You can still apply for your 10-year green card going from the 2-year green card without that spouse being involved. But you have to know how to approach it. This is essential because if you do not approach this situation correctly, you will end up in problems and with a possible denied 10-year green card. So as soon as you know you have your 2-year and you know that you're not moving forward with your spouse anymore, that you have to apply for the 10-year without your spouse, you're going to have to apply for a special waiver. And you have to make a proactive effort. This is not automatic. Immigration is not going to, you can't go to the interview and say, hi, we're separated. We got a divorce. Can you just give me the 10-year? It doesn't work that way, right? So you must be proactive in order to file a special waiver that once they get this waiver, they know that you're applying for this 10-year on your own. So this whole process I'm describing is called removal of conditions. It's not called renewing your 2-year. Sometimes you'll hear me say that just because it's easier to explain that. Most people know what renewing a green card is. But when you're going from a 2-year green card to a 10-year, it's called removing conditions, and there's a special form that you have to file called the I-751. The thing about this is usually when you get your green card through your spouse and you've been married for 2 years or less, or less than 2 years to your spouse, at the time you're approved, you're going to get a 2-year green card. If you're married more than 2 years on the date that you're approved, you're going to get a 10-year. So if you get a 2-year and but at on the date of approval that you got the 2-year, you really you were married for more than 2 years, you're really supposed to get a 10-year, and you can make that correction to get the 10-year right off the bat. But if married for 2 or less years, then you're going to be issued a 2-year green card. Now, I like to describe this as a probationary period where the immigration wants to give you 2 years to continue to gather your evidence, to continue to live together as a married couple. And then they're going to go ahead and say 90 days within, you should apply to remove the conditions, the temporary conditions on your 2-year green card within 90 days before that card expires, the 2-year green card expires. At that point, you're going to have to make sure that you file jointly with your spouse. You're not allowed to file without your spouse. Your spouse and you are going to have to sign it jointly. So this is where the problem lies. If you just got your 2-year and then you realize, oh my gosh, when I'm going to the 10-year, I won't have my spouse present to sign these documents, then it's time to apply along with the removal of conditions application, the I-751, you're going to apply for the waiver. a waiver that's going to allow you, but there are three bases. You can apply for multiple of them at the same time or choose one, but there are going to be three bases that you're going to apply for this under. You're going to apply based on a divorce. Usually at the time they approve it, they have to see an official divorce decree, but we do put Immigration Service on notice that you filed for divorce, even though you may not have your divorce finalized yet. We do put them on notice by sending them the petition of divorce and sending them any additional evidence of the bona fide marriage, because you still have to show that even though the marriage didn't work out, it was completely real. So we put them on notice that you filed for divorce, or if you already have your divorce decree, your finalized divorce decree, we send it in to immigration and we submit our brief on top, making an argument for the waiver based on divorce. That's going to allow the officer now, and the officer examining your application, not to expect your spouse to be present at the interview, or they're no longer gonna expect your spouse to be involved in the process. The second option for a waiver is if say you're with your spouse still, say you're living with them, but they are treating you badly, they're mistreating you, and you don't trust them to go through the process, or say you separated because of the mistreatment, then at that point you're going to apply based on your mistreatment, based on the mistreatment. So based on abuse, based on physical, verbal, financial, emotional mistreatment or extreme cruelty. So, for example, even if they are threatening your immigration status, that is a form of extreme cruelty that can qualify you for this type of waiver, whether you're still with them or not. You're not required to show you terminated the marriage by divorce. The last one is if you are going to face extreme hardship. So something has happened in the past 2 years that if you end up going back to your country, because by the way, if you do not do this right and you get denied, they send you to immigration court for deportation. So it's essential that you make sure that you do this process right, because this can put you in deportation, removal proceedings. So in the last part, they say that if you can show, the option you have is if you can show that, your life has gone in a direction in the past 2 years that will result in your extreme hardship if you're removed from the country, or if you lose your status, that they'll grant it then as well. The last option, you're not necessarily required to show that your marriage is bona fide. Of course, the threshold is high. It can't be just your usual inconveniences, like, oh, if I go back to my country, it's going to be really hard to start over. It has to be a higher standard than that, right? It has to be something more severe than that. So an extreme hardship, not just an inconvenience or a hardship. You can use one, two, or three of those, and I have succeeded on these using multiple waivers at the same time. So for example, in one case that we recently got approved, we used divorce because the divorce was finalized, as well as mistreatment. So if one fails, the officer has to consider the waiver. So say the officer isn't convinced on one, then they'll be convinced on the other. They can evaluate the other. So if you can at least meet the requirements for one of the waivers, you'll be approved. So here's where you need to make sure that you get on that right away. Because if you wait and apply, you don't do this, you'll be denied. And another thing is they can question if, say, right when you got the 2 years, you're separated or divorced, then they can look at it also as, well, this was fraud. For sure, this was marriage fraud because you divorced right after you got the 2-year green card, right? So another benefit of this is you get a head start. Once you know that you are divorced, you're separated, you're not moving forward jointly with your spouse, you can actually start to take take the conditions of your 2 year to a 10 year before that time, the 2 year expires. At any point that you know you're gonna divorce, you can apply for removal of conditions. So you get a head start on the process. Why this is a benefit is because this is taking 2 to 4 years. So that means that while you still have your green card, they will you can actually start on getting the 10 year before your 2 year expires. So you will have a head start depending on how soon you start. So say you start a year into your 2 year green card, um, then that means it will cut the process by 1 year, because right now it's 2 to 4 years. So for this process to go through. So this is where I say definitely don't pretend as if this is not happening. The 2 years will pass very quickly. So make sure you do it right. As soon as you know you're not moving forward with your spouse and you're on the 2 year, it's time to give us a call, time to talk about how to move forward to get that 10 year. Now, what I'm going to do is I'm going to go ahead and answer questions. I see many questions coming in, so let me go ahead and answer some here. So I'm going to go to each platform as I usually do. Can you address divorce or separation after getting the extended 48 months green card? Then you need to make sure you do the waiver. Give us a call. This is what we do for our clients. Don't go it alone. Give us a call because it's time to apply for it. But now you have to address the waiver. You can't sit there and wait for them to call for an interview and then tell them at the interview you're divorced, because they may deny it because they didn't get a formal waiver. Can someone who have a 10-year green card get married to someone for them to get their green card? Yes, yes, absolutely. Permanent residents can petition for their spouse. Now, where you need to be careful with this is if, say, you got your green card through a spouse, and then you divorced that spouse after you got you divorced that spouse within 5 years. You can't get remarried and file for somebody else within 5 years. You have to either get your citizenship and then move forward, or wait for 5 years and then petition for a spouse. The reason being, once you divorce a spouse and you get married within 5 years of getting the green card, right after you divorce the spouse, then and if you try to petition anybody else, they hold that second marriage-based process at a very high standard. You have to show by clear and convincing evidence that the marriage is real. That is very, very, that they have to know that you're married almost without a doubt. And in addition, and so the standard is they deny it, or you show by clear and convincing evidence that this marriage and the previous marriage is real. So what that means also is that you could face, even if that first marriage was not fraud, it can open up a can of worms, because the immigration officer can look back, they can reopen your past filing, and you could end up losing your green card instead of actually petitioning for your spouse. Because if they come to any determination that first marriage was fraudulent, and you'd be surprised how often they throw out this accusation, then you could be in trouble, and you would be without a green card plus your spouse. Should one report an EAD card loss although they already have a green card? So no, I mean, it's not something that should be a huge concern. You're not necessarily, if you already have a green card, you're not going to replace an EAD. If you feel like, though, somebody has taken this EAD card to use it for unscrupulous reasons, you definitely want to have this documented, because you don't want people to be using an EAD card floating out there for fraudulent reasons, and then your name gets caught up in it. So, to be careful, to make sure that this is documented on the public record that you lost your card or it is stolen. Make sure you take those precautions, because if somebody stole your EAD card, that's a work permit, and they're now maybe selling it, using the information on it to work, you may have a problem with immigration. They may try to even say you perpetrated that scheme. So you want to make sure you're careful. So if you feel like it's stolen, definitely report it. What's the consultation cost? $150. What should be noticed for Form I-130 about USCIS sent a notice by mail, but we didn't receive it? So if you file an I-130, you'll get a receipt notice. That just says it's in process, but you get multiple receipt notices. You get one for biometrics. You get one for approval. You get one for a request for evidence. So it's so important that you get your mail. What about if you got married, put the papers in, then your husband dies? Then there is a separate application process for widows of U.S. citizens. What's the current wait time for green card? And by the way, for that one, you have up to 2 years to file it, so be sure you're on top of that. What's the current wait time for green card for married couples? One is citizen married for 3 years. So I would say 10 to 12 months. Should one, so I answered that. Your spouse is a teacher, holds H-1B, and you have an H-4. Are you able to apply for EAD to apply for work permit? So not off the bat. Your spouse has to meet specific requirements for you to be able to qualify for the H-4 for a work permit. Now, there is the H-4 work permit for those who are being abused or mistreated by a spouse with an H-1B visa. So that's a separate process. Of course, you have to show mistreatment. But in regards to just getting the work permit based on having H-4, that is not usually an option unless you can show that the spouse is being petitioned for permanent residence by the employer. So there are certain criteria. If I marry my boyfriend while my T visa is processing, can I add him to my filing in the process? Yes, that's absolutely. Is it possible to get a travel document while you wait for the green card? Yes, through adjustment of status, you do qualify for a travel document, and I don't go without it for my clients. Even if my clients don't intend to use it, I still apply for it for them. How long does it take to get a marriage green card? I'd say 10 to 12 months if you're in the country. If you're outside of the country, then it's going to be a little longer. The report was made to the police already. There's no way to report it on USCIS. The only option on there is to apply for another one. Now, keep in mind that your initial question was, if you have a green card, do you have to report the EAD? So you don't need to reapply for an EAD, but you just want to have it on the record somewhere that it was reported. So it sounds like you're doing the right thing, having it on public record. So USCIS wouldn't necessarily take a report like that, but if an accusation does come up or some issue comes up, you can show a police report. Make sure you keep that police report on the stolen EAD. If your husband dies after the paper got submitted, what's the next step can one take? So you're going to have to file an I-360 petition, widow's petition. So that one you can give us a call. We can get started on it right away. You have up to 2 years to apply for it. Okay, so just got out of jail, about to renew my expired EAD. Do I have to tell USCIS about having been in jail and out on deferred action? So you want to make sure that they're updated on your record, because they may construe this as an omission at the point where they're making a decision. So now, keep in mind, this is a complex situation. I'm not your attorney. I'm not giving you personalized legal advice. the specific approach to be able to update them is going to be dependent on the facts here. And so this is where it's so important. Anytime there's criminal issues involved, get an attorney. I can't stress that enough, because it does go into complex territory, and the way we approach those are on a case-by-case basis. Can I file for my marriage green card immediately after my marriage to a U.S. citizen? Yes, but here's my next question. You can. There's no rule that says you can't, but is it advisable? That's the question, because do you have everything that you need to file? Are you making sure that, because having everything lined up for this application is essential, especially if you want it to be waived and you don't want to go to an interview. So important to have your evidence lined up properly so that you're able to present the best case at the forefront and get your green card in the mail. So, get legal advice to make sure you have all your ducks lined up. Thank you so much, Beth. I appreciate that. How can someone apply for a travel document? So if you're applying for adjustment of status, then you can apply for the travel document along with the adjustment of status. And then, there are specific instructions on where you need to file, just depending on what state you're in and all of that. How long does it take to get your citizenship after applying? Right now, I'd say 2 to 8 months. So the average on USCIS is 6 months. For my clients, I've seen them in as short as 2 months and about 8 months. So 2 to 8 months. How long does UT take for the green card to be approved if you get your work permit and socials? So it's going to range. Now with UT, I'm not sure what that is. It's not ringing a bell for me for UT. So just spell it out for me. I might be a little slow today. What's the best time to file for the renewal of a green card? Right away when it's expired. That's gonna, right before it expires. I would say even 6 months before it expires, that you need to renew the green card. And now another question I have is why, and you may have good reasons not to apply for citizenship, but have you considered U.S. citizenship? If your green card is expiring, your 10-year green card is expiring, that means that you very well may qualify for citizenship. Have you looked into that? As a citizen, you have so many more benefits. For one, you have complete freedom. You're not going to fear deportation. They don't deport you. If you're a U.S. citizen, you can vote, you can participate in the process. There are even federal jobs that you can take as a U.S. citizen. You can go outside of the United States to go live anywhere you want for as long as you want. Now, the downside is if you leave the country, you have to pay taxes no matter where you are. But that's the price we pay for being U.S. citizens. And you don't have to worry about how long you're going to leave the country to even visit other countries. And then you get to travel without needing a visa or having to go through the hoops of getting visas to go to other countries. So there's so many benefits associated with being a U.S. citizen. So, make sure you don't delay that. I see so many people delay that process unnecessarily and then regret it later on. How long does it take to get your work permit after submitting AOS form? So I'd say 3 to 6 months, 8 to 12 months for the VAWA. What's the processing time and it's getting shorter, by the way, for VAWA, because we're getting them much faster for our clients. So around 6 months now for our clients. What's the processing time for a green card and adjustment of status? It depends on what kind of green card. How long does it take to get your green card after receiving your work permit and social? It's all over the place. I usually just go from the date of filing. So if it's marriage based, if it's family based, you're looking at I'd say 10 to 12 months. If If it's VAWA, then your work permit comes in about 8 to 12 months. Your green card comes in about 2.5 years. If you're married to a US citizen and living in another country, but you didn't send off your paperwork and your husband died, can you do anything? Yes, you can. You can apply for the I-360 as a widow. You have 2 years to apply for it. When can you apply for citizenship when married to a US citizen? 3 years. All right, so I'm moving here to get to the questions here. So, hi there, good afternoon, Arlene. Nice to see you. Hi, Anagate. When you file and all the forms, I-130, I-131, I-864, I-405 at once at Chicago Lockbox, how long does it take to get your receipt? So I'd say a week to 2 weeks. My VAWA has been pending for 34 months now. How long more I wait for? So I'm seeing decisions in 2.5 to 3 years. So while I keep in mind there's no exact number here, everything is either averages that I'm saying or based on my experience. So if you're not on the lower end of 2.5 years, then you're probably more on the 3 year side. I filed my marriage-based case October 2023, got my work card in November that year by okay, so I think it's saying here, okay, the I-130 is taking longer than usual. So unfortunately, yes, a lot of people are getting those messages. If you go to an interview and they separate you, but it didn't go well, but the officer tell you your medical is expired, but she tells you to renew it, what do you think about that? So they're now the medical no longer expires. So that's I don't know when you did the interview, but if it's after the effective date, which was like a month or two ago, it shouldn't be expired. Medicals go forever now, no expiration. They just changed that. If they separated you, I've seen them deny it based on separation. My advice to you is don't wait. Get the attorney now. So yesterday, if this happened yesterday, medicals don't expire, right? So that sounds like there's an error there. But this is where it's very, very important to get a lawyer. I can't stress this enough because you're at a point where if the interview didn't go well, the officer is telling you now that your medical is expired. It's time to get the lawyer to help fix the situation. We've done this for our clients and it has turned out really well. Now, the thing about this is that they may issue a notice of intent to deny, and you want to make sure you have a lawyer on hand to respond to that notice of intent to deny, because we have reversed those notice of intent to denies when we've gotten it early. Usually they put a 30-day deadline to respond before they make a final decision, and it's basically your chance to change their mind. So very important here. And when it comes to the medical, we would have to just look at the specific rules here. So medicals no longer expire, but I'd have to look at from what date. Is it medicals that were signed on the date they made the deposit change, and any other medicals are still subject to the 2 years. So we'd have to look at that. But this is where I say get a lawyer. I can't stress it enough. Give us a call. We'll be more than happy to help you to fix everything that's going on here. T visa, but living with my spouse, will he know about this filing? So with our clients, it's completely confidential, and we have worked with our clients who have lived with the trafficker, the person that's doing the mistreating and the abuse. They have been living with them and they didn't have an inkling that this was happening because of the confidentiality and because we are very careful with our clients. So while I don't know your case, I'm not your lawyer, this is where, give us a call. Let's talk about it, and then we can work with you to do this safely. Um, why does I-824 take so long to approve? I know it's frustrating. They just released some policies on that. Now, the I-824 is a form that you have to file to basically move the documents from the United States to the NVC. And this has become a big problem because what happens is when people are filling out the I-130, they will put that their relative is going to do adjustment of status. So listen up. This is very, very, if you don't have a lawyer working on this, very important you hear this. I-130, do not put adjustment of status on the I-130 if your relative is outside of the United States. Because what's going to happen is upon approval of the I-130 petition, they're not going to send it to the country where your relative is. They're going to hold it at the USCIS. And what's going to happen is they're going to hold it until you find out that they're holding it, because now you're realizing this is taking longer than you thought. And then you're going to have to file an I-824 form to get it moved to that country. Right now, they're taking upwards of a year to be approved. So the way you avoid this mistake is by making sure you determine from the get-go, is your relative here in the US, and will they be doing the green card process in the US? And that's if they live in the US. Or are they going to be in their country at the time that it's approved and be doing it in their country? It's called consular processing if they're doing it outside of the country, and it's called adjustment of status if they're going to be doing it here in the country. If your relative is outside of the US, or even if they're visiting on a visa, do not put adjustment of status unless they truly qualify for adjustment of status, or you will have to go through this extra paperwork. So they just release extra policy. So they release an extra policy change here, just stating as well that if you put neither, they are going to hold it. So they now have a process for you to make the correction before the approval so that they can send it to the right place. So just take note here, but I empathize with you on that one. Is there a legal way to help a family member get through an entry port legally? So usually you wouldn't have control over that. When they're coming through the port of entry, they're either going to have to request parole based on humanitarian or urgent need, or they're going to have to declare asylum. Of course, we know now that at the southern border, there are new policies in place that they also have to be aware of, because it could be detrimental if they don't follow the rules or they don't follow what's going on. If they try to come to the port of entry while it's locked down, because there may be too many people trying to get in illegally, then they can turn them around without even finding out what their reason is, and then ban them from ever coming back to the US for 5 years. So, it's based on if they're trying to come in because of an issue like that, they would have to declare it themselves. A family member can't do it for them. Of course, you have programs going on right now, but these are for specific countries like Haiti, for example, where they can be sponsored by an individual here. But they go through a CBP app, make an appointment, and then get paroled into the country. So that's a separate process just for specific countries. If I'm married to a green card holder and overstayed in the US, can I get a work permit and SSN? Not right off the bat. And this is where, when we do consultations with this fact pattern, we look at alternative options, or you wait until the green card holder spouse can become a citizen. I got the 10 off the bat. I was so lucky. Yes. And sometimes here's the upside of the long processing times with the marriage-based process, is that you get the 10-year when it's all over. So you don't have to go through the process again. Is herbs going to affect your green card? Yes, absolutely. So let me tell you one thing though. Do not do not go to any interview and tell the officer that you had possession of marijuana. Whatever you're disclosing, you have to be very clear on it, because if you do say you had possession, they can construe it as you were distributing marijuana, and guess what? It bars you for life. So you have to make sure that you understand how you should approach a situation like this. Now, if you said you've used marijuana before, usually they will put you in the category of a abuser, and then you have to go through a medical all over again to show that you are clean now and you're no longer addicted or using marijuana. So there is a way around that. But once they put you in the drug trafficker, or you're in possession of even marijuana, even though, yes, it's legal in some states, by the way, even though it's legal in some states, they still are adhering to the federal standard that it's illegal. So do not be very careful with this. I am waiting 121 days to my green card been approved. How long I'll wait on it? Thanks. So it depends on what's going on in your case. Approved for VAWA, congrats. If you married a US citizen, apply immediately for citizenship. You don't have to wait on the 5-year grace. You can't apply immediately for citizenship as the spouse of a citizen. So you have, if this is a statement here, I don't know if this is a question or a statement. If it's a statement, it's completely wrong. For people who have been deported, what's the length for the ban in the US? So it ranges from 5 years to 20 years, and sometimes for life. But usually, even if it's for life, you have to be outside of the US for 20 years before you can apply to come back. Can you apply for a gun permit as a T status person? Uh, I don't see why not. As long as you qualify for a gun permit and you have the immigration status, if they do even require you to have an immigration status, then you're able to. But this is more of a question for whoever is going to determine that qualification. When do you get citizenship if you're married a citizen? 3 years. Do you recommend someone who's on filing to get a US visa for stepdaughter's graduation? It's possible. Okay, I have undocumented parents. How can they get their papers? So every lawyer said they can't get it. So I represent clients who have been in the same situation. And what I say here is I can't tell you that your parents are going to qualify unless I do my own evaluation. But I do look at options. So often lawyers are quick to say, if they hear you're undocumented, you're not married, they are quick to say you don't qualify for anything. And I don't do that. I look at alternative options to be able to get you your papers. There is relief out there. And so I ask some questions to see if they fit within that criteria of those alternatives. So this is where it's very important to get that consultation. All right. Awesome. Donna, I'm glad your son is going in for the appointment. It means things are moving along. All right. How long is the process time for the T visa? So about 12 months. So it can range from 6 months to 18 months. Based on my experience, I'm seeing about 12 months on average. If I'm married a US citizen, how long after I can start my paperwork? It depends. If you have everything that you need to go, then you'll be ready. All right. Thanks so much, everyone, for your time again. I'll be back. I'm aiming to be back tomorrow. As I've said before, follow me, like, subscribe, do whatever you can so that I end up on your feed so that when I come on, you can see me and then you can join me as soon as you see me come on. All right. So have a great day. Remember, if you want to get in touch with me, go to the link in the profile, click on the link, and then schedule. You can schedule your own appointment. You can also call the office and they can help you to schedule. Our schedules are filling up. So it's attorney, it's me, Attorney Bria, who do the consultations right now, and Attorney Bria and I work very closely to determine which of our clients can qualify for the relief that not a lot of attorneys look for alternative relief to get the work permit, to get the green card. So take those steps, get on my schedule so we can change your life and get you in the position you want to be here in the US. Have a great one. Bye bye.